Recording in progress.
Oh, and it's being recorded, so now you all consent. Just a bit of housekeeping for us all, and apologize for this, but I think a lot of this is helpful. First of all, we always welcome constructive feedback in connection with this program. Somebody said last week, we asked like, well, what would we improve? And somebody's like, more breaks would be nice. So we added that. So we're gonna have 2 breaks this year. So now you can just listen with rapt attention, and then everyone can just check their phones and text at the breaks. I'm sure that'll happen, right? In any case, want to talk just for a moment about MCLE for anybody here who's a attorney. You can get it if you're here in person. Hopefully, pick up a form, which you have, and if you're on Zoom, there'll be MCLE forms that are emailed by the end of the week for you. And now, I've done this sometimes, but now I'm told that this is mandatory, that we are going to be issuing a 1-word code word towards the middle of the presentation. Although it'll be before the end of the second break, I'm told. Or sorry, really before we start the second break. There's a 1 word, and we need to hear that in order to get the MCLE, I guess, it's keep everybody honest. If you're here in person, please make sure to get a parking validation. If you don't, I mean, the cost of parking in this building is absolutely shocking, in case anyone's ever had to pay that without a validation. So please do that. There are restrooms located at either end of the hallway, right? So I feel like a flight attendant here. The Wi-Fi password information is also available if you're here in person. It's located in the front of the room. Please join us here in person, if you're here in person, for lunch after this. We are going to walk / elevate upstairs. And who said there's no such thing as a free lunch, right? There is. And if you're on Zoom and you want to stop by, please feel free to do so. And sure. Okay, there we go. Side there. So yeah, we have lunch, and we decided to do it this year in our lovely offices. So you can see those again if you haven't in a while. Just a few quick notes for anybody who, oh, and by the way, just to get up there, I'll probably say this again, but last time there was a bit of a traffic jam, everyone having to like sign in at the front desk to get a pass. This year, he's gonna find an MSK buddy, and we can just escort you upstairs. So that's nice. If you're on Zoom, please mute your microphones during the presentation. I think we all have hopefully have figured out Zoom by now, so I don't think that should be too hard. And if you have a question, you can feel free to type it in the chat box. We may not be able to get to it today, but what we do with those comments, we certainly see them, and we can address them afterwards. And either I or my colleagues who are presenting have responded to every question that is sent to us. So feel free to ask away. Maybe I'm bringing that on myself, but yeah, no, please do ask. And we want to hear what your questions are. That's the end of the housekeeping. Just to talk about some trends. By the way, I realized for some of you may not know me, but my name is Jeremy Mittman. I'm a partner in the Labor and Employment Department here at MSK. I think I've helped shepherd this program the last, I don't know, 3-4 years. And it's gonna be a great one today. I can guarantee that because I've seen what everybody's gonna say. I think it's gonna be really helpful. I mean, pretty much, I can't say I can guarantee it's everything that you need to know for this year, but it's pretty close. There's some really detailed, fine, granular stuff, but we really try and focus on the big picture. And certainly that's why you can reach out to us if you have any questions. Also, for example, my presentation and others, we may not read every word on the slide or even every bullet point on the slide. And that's okay, because we're going to be sending you, everybody, both in person and online, a copy of the slides for you to have and use as a resource. So hopefully that will help. In terms of trends and what have we seen or what are we going to see, hard to tell a little bit. We're kind of in the infancy. There's something called DEI programs. I don't know if anybody's heard about any of those in the news. There's news flash. Trump doesn't really seem to like them very much. I don't think that's a secret. And so we've heard a lot about that. I mean, right when he was sworn in, you saw some executive orders come out. We're not really going to be talking about that so much today. It does affect federal contractors, not certainly some, but I would say a minority of our clients are federal contractors. So I'm not going to really get into that into detail about that. But certainly in the last week, we've seen attorney generals from 19 states issue a letter basically kind of falling in line with that philosophy and saying, we're going to look into this. And then just a few days ago, I saw that there were 16 attorney generals from, let's just say, mostly what you would call blue states saying DI programs are great. And if they're well drafted and executed, they foster diversity and are a great value and do not violate the law, certainly. And so we'll kind of see how this all plays out. It could be interesting to see what happens. In terms of something perhaps more directly relevant to employers that may that you all may see and fear, it continues to be the case that juries in California and especially including but not limited to Los Angeles are continuing to hand out astounding, shocking jury verdicts with stunning and alarming regularity. And sometimes you scratch your head and you think, really, how did this happen? For example, just last month, there was a case in LA with a jury, Roche versus Octo Pharma Plasma. Sounds like an evil corporation. I don't know. I hope they're not a client. No, but no, they're not. And a jury returned a verdict of $11 million. This was an interesting case. Looking at the 11 million, there were actually zero economic damages or there were no lost wages. That's because the plaintiff was 74 years old. Yes, she decided to stop working, but she alleged that she was denied a reasonable accommodation because the company wouldn't provide her a chair in connection with work. There is like a suitable seating law in California, but this was kind of an ADA FIHA type issue for failing to provide an accommodation. She was a medical screener at this Octo Pharma company, and she alleged also she was terminated because of her age. And she won $11 million. But that really pales in comparison to what has to be the largest jury verdict that I've ever seen in employment, which was just a few months ago last year, where a jury in Los Angeles returned a verdict of $900 million. That's not a mistake that I just said, $900 million. It was against a billionaire, Alki Davis, and it was from a former employee who did allege, and the jury certainly found credible and believable, some really horrific allegations of sexual assault, as well as sexual harassment as a former employee. The court then reduced that from 900 million to just $90 million, and retain the same punitive damages ratio of 8-to-1. But that's certainly an outlier, right, in terms of high verdicts. But it does really exemplify some very high jury verdicts, which everybody needs to be careful about. It's a really good reason to make sure that we're all compliant, because you really never know. And of course, as Steve Rossi will explain to us in connection with his presentation on the latest in arbitration agreements, that is really the solution in many respects to avoiding something like this, at least hopefully. Well, those are just some general trends that I've seen. Let's hop into some updates, shall we? And first, I'm going to talk about some new laws that have come about for us to think about for 2025. And let's chat about them a little bit. That's me, by the way. Okay. Well, that was 6 years ago. Do I still look? There's a little bit more gray, but anyway, yeah, look at the picture stuff. Okay, anyway, that's me. So let's talk about some new laws and regulations. Okay, well, we always just start with this because I think that we just shouldn't forget that as of January 1st, 2025, the minimum wage in California is now $16.50 an hour. So it went up a little bit. And you may think, well, I don't even have any employees who earn that little. But for me, really the more important number is the salary basis threshold, which has increased, right? So what does that mean? For some of us who may not know, it means that if in order to pay an exempt, i.e. a salaried employee in California, you must pay them at least $68,640. It's virtually the case that if you have a salaried employee who's earning less than that, they likely do not qualify as being exempt and therefore could be entitled to various causes of action as a result of a misclassification. So that's a really important number to know, and certainly significantly higher than federal law and really the rest of the country, I would say. Also important to note that there are various jurisdictions and cities that have a higher minimum wage. So for example, here in LA, it's $17.28. Los Angeles County doesn't come up that much, but because it only applies to unincorporated areas in Los Angeles County. And it's just a hair under, and then as of July 1st, both those numbers will be increasing by about 60 cents or so. Sometimes people wonder, well, like, if the salary basis test is 2 times the state minimum wage, which it is, you have to look at these numbers and figure out where the employee is located. Fortunately, you don't. It really just goes by the state minimum wage.
Jeremy, I'm sorry, did you just say that, I'm just trying to understand your last comment.
Yes.
To determine if you are salary exempt, you still just focus on the state?
That's right.
Okay,
That's right.
good to know, thank you.
See, don't be afraid to ask a question. Even lawyers may not. Oh, by the way, which reminds me, thank you, Jonathan, for raising your hand, because this is a shameless plug for another presentation and program that we're gonna be doing next week. I believe it's February 26th. This one's just over Zoom, and we're just focusing on labor updates, right? I would say this is an employment update, labor updates, unions, guilds, so forth. And we decided to do that because there's so many updates to tell you about that we wanted to really focus and not deprive you of those updates. But also recognizing that some people may not have a unionized workforce, but as I'm sure you'll hear from Jonathan and my colleagues, that there are certain laws that even apply to private employers, sometimes if you don't have unions, for example, under the National Labor Relations Act. Anyway, that was my shameless plug. So moving on. Okay, well, we have, there's a lot of detail here. I'm not gonna go into every single detail about this new law. As I said, we'll be sending you the slides so you can think about them, but I think this is actually an important one just to note, because this is one of the few, I would say, real handbook updates that you need to make as an employer. It's not a huge update, but we do have a model policy that addresses all the things I'll be talking about with respect to this new law concerning jury court and really especially victim time off, leave and accommodation provisions. So previously you had unpaid leave protections for covered victims of domestic violence, sexual assault, stalking, or crimes. I think that should sound familiar to many folks. But really what AB 2499 does, it expands quite significantly the various qualifying acts of violence is the way that the statute is phrased, to include various other reasons to be able to take leave. And some are quite specific, but you can see that there's quite a few more. For example, if someone caused bodily injury or death to another, there's brandishing of firearms, so forth. So hopefully someone doesn't come into contact with a lot of these issues, but certainly they do happen from time to time. So leave is expanded for that. And also, importantly, employees can now take time off if any of these things happen to affect family member as well. The law also explicitly states that employees can use paid sick leave or PTO for these purposes, because the leave is generally unpaid. And of course, there's protection against retaliation and so forth for exercising your rights to use it. Employees do need to provide a certification to substantiate that leave or accommodation. And there's many, let's just say this, there's many different ways that an employee could provide a certification, including just a catch-all, any other form of documentation. And so there's quite a few. You don't have to ask for certification if you don't want to, but certainly have the ability to. And but there are many different ways that an employee can provide that. A lot of these provisions are being moved to different areas of the statute. For example, now under FEHA, and authority now lies with California Civil Rights Division. And the reason for that is because it was just kind of, I would say, odd that the labor commissioner was in charge of looking into some of these things. And so now it's, I think, more appropriately with the CRD, which used to be the DFEH, by the way. Employers can limit the total leave taken to up to 12 weeks, and it's got to run concurrently with CIFRA or the FMLA if employees are eligible. Separately, where there's a family member that's a victim, someone can only take up to 10 days. And if it has to do with relocation specifically, right? If, for example, there's stalking or something going on, that is limited to 5 days. This is worth noting that employers have to provide written notice to employees of their rights under this. Right now, as of yet, I don't believe there is a form. CRD is supposed to publish that. And but I would say it could be also in a form of the employer's choosing, just as long as it covers all of the required points. And I would say that our policy really would cover that for the time being, certainly. Just on the subject of new notices, don't want to really spend a lot of time on this. There is a new notice requirement for a workers' compensation required notice in California. And gee, I wonder where this came from. But you specifically have to state that in connection with workers' compensation, that employees can get an attorney and that their fees are going to be paid as part of the award. This pamphlet is actually quite a long one. And so lest anybody wonder, like, oh, now employees are going to know that they have more rights to get a lawyer. I mean, it's really like a clause in a much larger document. I don't really think it's that big of an issue, but note that there is a revised one and it's out now. There's also, I just wanted to note back last year, I'm not sure, I think we did touch upon it briefly last year, but just there are updated pamphlets. There's a for-your benefit notice that's been updated. That's for a discharged employee. One of the few things you're actually required to give a discharged employee that touches upon unemployment insurance, as well as a few other things, different types of insurances. And then there's this Labor Code 2810.5 or an Anti-Wage Theft Protection Act notice that you are required to give every non-exempt employee in California. And that was updated last year. And the update was you have to, for any employee that's starting, provide notice if there's any disasters as determined by state or federal law that might affect where the employee is working. Well, in case you didn't think that we needed more pamphlets and notices and to be even thinking about that, there is also an updated whistleblower law notice so that employees are absolutely sure of what their rights are concerning their right to raise concerns about unlawful conduct or what they reasonably believe to be unlawful conduct in California. And just to give you an idea of how picky California can get, I would say annoyingly picky. The document has to be printed on 8.5 times 14-inch paper with margins no longer than 1/2 inch. in order to conform with the statutory requirement that the font be at least 14-point font. It's like, do we have enough things to worry about? But nonetheless, there is a model notice for that. My guess, however, though, is sometimes clients say like, they have a hard time keeping up with the notices and stuff. I mean, do yourself a favor and just buy the one poster that contains, right? The one poster that contains them all. For example, from Cal Chamber. I mean, it's not that expensive. And then frankly, you don't have to worry about this because I think your head will spin if you had to keep track of it. At least that's my advice to you all. This is an interesting one. I say only interesting because it's potentially the other handbook update that you may need to make. So this is an easy check. And by the way, if you don't have an employee handbook, then come to me. We'd be happy to help you out with that. By the way, shameless plug here. I'll just mention though that I really like the way we help employers out with handbooks. To a client, we just generally provide a 2025 compliant employee handbook that's up to date, and we provide that for free typically. The idea being, well, why should we charge for a template? I know other firms charge like $5,000, like here's your template, but we've already done the work, right? So why should we charge the client for that? At least that's my philosophy. And if you have any questions, we're happy to talk to you about them, right? If you have to conform it to the way that your particular business manages its operations. But I just wanted to let you know that certainly that is available. In any case, so here's the easy check. To check if your handbook says that employees are required to use up to 2 weeks of accrued vacation before applying for PFL, paid family leave benefits, right? I hate that phrase, the way it's called, because paid family leave does not afford for any actual leave, right? Discuss. But it's wage replacement, state provided insurance if an employee or really an employee's family member has a disability they have to care for, or for example, for new parents and so forth. In any case, in case you're wondering why that is, I actually did some research to find out like, well, what was the reason for that? And it's really just to encourage employees to take advantage of PFL benefits, lest there be an employee who would think they wouldn't want to apply because they would have to exhaust some vacation. I have to be honest though, I haven't actually found many handbooks that do have this requirement, perhaps just even one. So don't be surprised if it's not there, but just wanted to flag that for you. Okay, this is an interesting one. I don't think there's really that much to do with respect to this, but it is interesting. So it clarifies that the Fair Employment and Housing Act prohibits discrimination not just on the basis of an individual protected trait, but it could be a combination of 2 or more protected traits, which is called intersectionality. I thought this quote was quite interesting about where that comes from. And I have to be honest, when I saw this, I was kind of like, well, duh, right? I mean, if it protects one trait, then obviously it's going to protect a combination of traits. So why do we really even need that? But in doing some research on it, I came to realize that it's a little bit more nuanced than that, because there could be some circumstances where it's a particular combination of traits that leads to the discrimination, right? So it's not just, for example, that someone is of a particular religion and a particular race, but there was an example, just to make it more concrete, of a company that essentially hired, at least for women, white women for office work, and Black men were statistically significantly hired for manual work. And so Black women in that sense were treated adversely. So that's how that might work. Or to the extent that there may be some stereotype, for example, about, for example, Black women, and that combination specifically. So that's where it's at. I don't think that Trump particularly would think very highly of this type of addition to the FEHA. Interestingly, the EEOC's interpretive guidance contains just this concept, and it's still up there as of now. I think when he gets around to it, or his administration, I would be surprised if it's still up there, but nonetheless, it is. a very minor addition again. We're just kind of fiddling around the edges, but I thought nonetheless interesting, and it is a change to the law. I mean, it is so very narrow, by the way, but it amends the definition of race under FIA. This is in connection with, if you heard about the Crown Act, which we talked about perhaps a few years ago, California being, I think, the first state to institute that in terms of making sure that race is inclusive of traits associated with race. For example, hair texture and protective hairstyles. Really, it just took out the word historically. And in the legislative history that I read last night, it was talking about how just historically was ambiguous. So they want to just be very clear about that. Again, a very minor point, but nonetheless, a change to the law. Practical. This one's practical, actually. Believe it or not, now in California, you cannot say that a driver's license is required for a job in California for a job posting or a job application, unless, and I think this makes sense, the employer reasonably expects the employee to use a car for work. In that case, it would be relevant, and as well as if you reasonably believe that it would be inconvenienced in a way, let's just say. And interestingly, the reason for that, which I think makes sense, I was looking at the legislative history, requiring driver's license disproportionately impacts people with disabilities, low-income individuals, and those living in urban areas with access to public transportation. So that's the reason for the law. I've gotten a few calls about this and helped out several clients who I know certainly the 130 must be on the call. And I think they'll tell you this isn't that bad, actually, but there are some very important changes needed to your independent contractor agreements in California for certain specific types of roles, which I'll get into in a moment. Although I will mention that in Los Angeles, it's unusual for Los Angeles to have a law that kind of governs broadly on something like this, but it does. Los Angeles does have its own independent contractor law that I would say mirrors this a little bit. But for California, there are certain required items and provisions that need to be in an independent contractor agreement. And of the contracts I've seen, many are there already, but some are not. And for example, due dates for the worker to report completed services or be paid, basically stating all the conditions precedent that need to happen in order for a contractor to be timely paid. And it's for freelance workers specifically, but that's a very broad term. It's defined under the law as someone providing professional services which can include, really, there's several types of jobs here. And I'm not going to go through all of them with you. You're going to get the slides anyway, and you can talk to us about whether you think that the changes are needed. I think they're just good changes anyway, frankly. I don't think that they're so onerous. So I would recommend you taking a look at your independent contractor agreements and making these changes. There's certain other requirements, and obviously, you can't, by the way, force an employee to importantly, not an employee, a contractor to accept less compensation in order to receive timely payment. You can't like change the terms on them. Here's another law that received some certainly a fair amount of press. And I'm not going to get into too much because I know that Jonathan and his team will be talking all about this next week. And it's called the California Worker Freedom from Employer Intimidation Act. And basically what this is getting at, it's people keep on talking about it in terms of unions, required meetings for employers to talk about their perspective on unions and labor organizations. It also covers if an employer were to gather employees together and require them to speak about or to hear about religious or political matters. And you could even be paying the employee. It could be during working time, but this California law says that you can't do that. It does follow, there are several other states that have laws like this, maybe about 10 or so, I think. So an interesting example of California not leading the way in a law, but certainly there it is subject to ongoing litigation. Almost immediately, the California Chamber of Commerce filed a lawsuit challenging the law on various grounds, preemption under the National Labor Relations Act, as well as perhaps like constitutional issues. So we'll see how that shakes out. I want to just touch on this briefly. Not going to talk about all the things on the slide. I just wanted to remind you all that as of last year, employers are now required to have a comprehensive workplace violence protection plan, and it's quite detailed. There's a lot of things that you have to put in that plan. Fortunately, California provides a decent model for that. So it's just available on the OSHA website, and it's something that we regularly help clients with. But fortunately, that is there as an aid, and there are some potentially significant monetary violations for not having one. And it's my general sense that there's not as widespread compliance as there probably should be in terms of having this plan. I'm not going to take a poll certainly to ask who doesn't have one. But I would suspect there's quite a few folks who may not have gotten around to that yet, or perhaps even known about it if you weren't here last year. So I did want to remind you about that. As well as newer, I don't think this applies to many of our clients here, but I do want to note, and I did advise a client on it, certainly, but it's a new regulation under Cal OSHA as of last year, but we didn't talk about it because our presentation was back in January of 2024. But it applies to all indoor work areas where the temperature equals or exceeds 82 degrees when employees are present, with a few exceptions. Again, because I don't think that this has widespread applicability to many folks. I'm not going to go into the details, but certainly we were providing you for there. And Cal OSHA has a very handy chart, by the way, of what the rules are, as like a cheat sheet, both for for indoor and outdoor workplaces. There is good news. There was a PAGA Reform Act. Finally, some measure of relief to employers about the bane of many California businesses. I'm not going to get into it in too much detail. It's very specific and granular. But just some of the highlights is that although penalties are increased, the share of penalties are increased, is only a very small amount actually went to the employees. That's been increased, but there's a lot of relief. There's monetary caps. Maximum penalties can be reduced for employers with weekly pay cycles. Penalties are reduced by 50%. That's because AGA goes by penalties by pay periods. So in a way, you are penalized by having weekly pay periods, but that's no more. And there's additional facets to it. See Gary McLaughlin in our audience, and he's certainly at least the person who I often look to as a wage and hour guru, and just has a fantastic wealth of knowledge. If someone has specific questions of that, certainly you can reach out to us. Be happy to put you in touch with Gary or many others of our team who know about this. Last but not least, again, not super applicable to many of our clients, but I just thought it was interesting, and certainly a new law in California for child bloggers. And like video blog, probably like I don't need me to explain that. But it basically adds them to the Coogan law, which means, for example, that if they are compensated by a company in connection with child blogging, that 15% be withheld and segregated in a block trust account. That's the Coogan law, essentially. And it also protects minors. Yes, there's a lot of text there, but basically they are rules to ensure that minors are treated safely and fairly in connection if they are producing content as a minor. And there's certain various requirements in order to fall within that law, but it's something to keep in mind if there's any vlogging. And by the way, perhaps you have a business too where you're advertising and there's minor vlogging in that sense, or a minor appears in a video blog. In any case, I think that's pretty much all she wrote in terms of updates for new laws and regulations. So now it's my distinct pleasure to introduce you to Talia Citrin, Really, I can say one of our star associates who's new, and she's going to tell you all about discrimination and harassment case updates. Taya, come on up.
Thank you, Jeremy. Good morning, everyone here and on Zoom. My name is Talia Citrin. I'm an associate here in the Labor and Employment Division. I've been here for a little over a year. Previously, I was working at the U.S. Attorney's Office. So today I'm going to talk to you all about some notable cases and interesting updates in discrimination and harassment law for 2024. So first, we're going to look at Bailey versus San Francisco District Attorneys. This case got a lot of buzz in the legal world. So I'm going to give you a little bit of background of the incident that actually happened. And if you can believe it, it actually all started with a mouse. Twanda Bailey was an African-American investigative assistant clerk at the DA's office. So she worked in the records room along with another clerk. One day, she's at her desk and a mouse runs in and runs underneath her desk. So understandably, she's very startled and she jumps up and her coworker walked over to her afterwards and looked at her directly and said, "You N-words are so scary." This was the only time she ever used this kind of language or this comment was ever made to her. So let's move on to the employer's response to this. So with Bailey's blessing, her supervisor reported the incident to HR. It makes its way all the way up to the chief administrative officer. The city policy, like many employers' policies, was to file a formal complaint once this was raised. But the city did not do that here. The two, Bailey and her coworker, were not separated after. They continued to work in the same records room. And a few months after the incident, Bailey asked to see the complaint that she had requested be filed, only to learn that no complaint was ever filed. At that time, she then requested that a complaint be filed and was refused and was told that she, by telling about this incident to her coworker, she was making a hostile work environment and causing harassment to the person who called her this offensive term. Sorry. No, neither can I. No, I'm sure. So afterwards, Bailey claims that this chief administrative officer that she complained to was intimidating her and belittling her and threatening her, including telling her, "You're gonna get it." Now, I know that we usually like to ask in these things, where did the employer go wrong? But for this one, I'd like to say, did the employer go right at all? It was pretty much a mess, right? So Bailey sued under the California Fair Employment and Housing Act, the FEHA, and she claimed harassment, discrimination, and retaliation based on her race. So here, the California Supreme Court reversed the lower courts and found that a single racial epithet can be so offensive that it gives rise to triable issues of actionable harassment. So what this means is that someone might be able to bring a harassment claim to trial based on one single comment alone. The court here said that it's going to look at the totality of the circumstances in determining whether or not the harassment was sufficiently severe or pervasive, or that's the standard that we use in harassment claims, to see if the claim will survive. So depending on the facts, even a one-time use of an offensive term can be a harassment claim. So typically, an employer is strictly liable if a supervisor is the one who is doing the harassing. But here, what the court was saying, it doesn't even matter if the person who used this one-time offensive term was a coworker. Now we're just going to look at that as one of the many factors in the totality of the circumstances test. In keeping with established law, the court is also going to look at, did the employer know about this? Did they have reason to know about this? And did they promptly and effectively respond once this came up? So here, with all the facts, the court found that this highly offensive term, along with the fact that the two were not separated, but they continued to have to cover for each other. If one person was out, the other one had to cover. The fact that the coworker said she was scary, that an officer completely ignored the complaint, and the fact that Bailey, she actually had a doctor's note saying that she was experiencing anxiety and depression because of the workplace stress. So all of this, under the totality of the circumstances, was enough to create a viable harassment claim. So the takeaway here with this Bailey case is that employers may have a harder time winning on a summary judgment motion with a harassment claim if even a one-time comment based on this test might be enough for a harassment claim. It's super important that employers robustly respond to complaints, even if it's just one time. One-time incident could be enough. Moving on to Muldrow versus City of St. Louis. So this is actually a Supreme Court case. I know that those don't often come up in these debates, but there was a development with Title VII, which is the federal anti-discrimination law. So with this case, Ms. Muldrow was a police officer who worked in the intelligence division in the St. Louis Police. She was transferred to another division against her wishes, but she kept the same pay and the same rank in this new position. However, she had different responsibilities, different perks, different job duties. She no longer could use the police car. She had a different a different schedule that she had to work weekends sometimes and not a regular 9 to 5. So there were some differences. So she sued under Title VII, claiming that this job transfer was discrimination based on her race. Based on her sex. So in this case, we had a unanimous opinion from the Supreme Court, which, as we know, is pretty rare. And the Supreme Court, looking into Title VII, said that the employee does not need to show that the resulting harm from this discriminatory job transfer was significant. Rather, all they have to do is show that there is some harm that is connected to the terms and conditions of their employment. So lower courts, many of them have read, oh, if you're going to allege a harm, it has to be something significant or substantial. The Supreme Court saying, no, law doesn't say that. We're not going to read that into it. As long as you can point to the employee can point to some harm, that will allow a Title VII claim to survive. So as you can see here, Justice Kavanaugh in the concurrence says that some harm can really include just about anything, right? It can include commuting, interest, professional relationships. Really, there's anything an employee can point to, because he's saying kind of the point of reading it like this is that a job transfer that's made because of someone's protected characteristic is wrong. So they're going to be able to point to basically just about anything to show some harm. The takeaway from Muldrow here is that, it's going to be very easy in a Title VII case for an employee to probably point to some harm relating to the terms and conditions of their employment. This decision specifically talked about job transfers, but it's very easy to see that you could probably use this kind of test for other employment-related decisions like, a weekend assignment or timing or things like that. Moving on to Okanowski versus Garland. As you can see from my great picture up here, this is talking about the perils of social media, which we might be familiar with. So this case is pretty interesting. Lindsay Okanowski was a staff psychologist at Lompoc Federal Prison. So she became aware of an Instagram account that had overtly racist, sexist, anti-Semitic, homophobic, and transphobic content on the page that both specifically and implicitly referred to prisoners, prison staff, and inmates. So excellent content. So basically, she also discovered, even worse, that she herself was sometimes targeted on this page with what the court describes as images based on her likeness. I don't know exactly what that means. Perhaps it's an animated picture or AI or something that kind of depicted her. So this page was followed by over 100 prison employees who often liked and commented and shared this page. So Okanowski later finds out that this page is run by a lieutenant at the prison who wasn't her supervisor, but she often worked alongside with him in working on the safety for the guards and the staff and the inmates. So let's talk about where the employer went wrong here. Okanowski complained to prison leadership, who told her that the page was funny, it wasn't a problem, she needed to toughen up and get a sense of humor. After she complained, she began to be increasingly targeted on the Instagram page with posts saying that the psychologist couldn't take a joke, and also even a suggestion using a particularly crude term that I'm not going to use here today, that custody officers who were attending a holiday party at her home may even come to attack her. So she leaves her job, understandably. She doesn't feel safe. She transfers to another prison, and she ended up suing under Title VII, claiming discrimination and harassment based on her sex. So what the court decided here is that in determining whether or not there's a viable harassment claim, conduct that takes place outside of the office, including on social media, can be harassment. Because we all know social media is absolutely everywhere, and it can be used at any time or any place to bully or to harass people, both inside and outside of the workplace. There's no excuse to say, well, it was private social media and it wasn't on company time and it wasn't on company premises. Additionally, when other employees might follow or like or share the account, that can clearly have an unreasonable effect on the working environment. Again, we see in this case that the court again used the totality of the circumstances standard in terms of evaluating whether there was a sexual harassment claim or not. Even if in this case, some of the content on the Instagram page might not have been directed exactly at Okanowski or explicitly sexual, the court saying the jury can look at all of this in the totality to determine whether or not this is severe or pervasive enough to be harassment. Additional factors that the court included here were the fact that these Instagram posts violated the Bureau of Prisons Code of Conduct, as well as their anti-harassment policies. Additionally, the fact that the lieutenant whose page it was charged with protecting the safety of others. So that was clearly a big factor in this case. The fact that Okanowski here was directly targeted was a big factor, but the court's pretty clear that you don't need to be directly targeted in social media conduct in order for it to be harassing, as long as it has a unreasonable effect on the working environment. So the takeaway here is that as employers, obviously you should take prompt and effective action if you are on notice of harassing conduct, even if it's not by supervisors who are doing the conduct or if it's on social media. It is critical that employees know that their own personal social media activity can be unlawful harassment. So a good idea there is to update your anti-harassment policies to include potentially private social media conduct could be harassment. And companies need to investigate any potentially harassing conduct on social media. Remember with that one, you have to tread lightly because there are legal limits. Employers don't have unfettered access to employees' social media, including their usernames or their passwords. Moving on to Palany versus Fireplace Products. So this case involved Erica Palany, who was an administrative assistant who decided to undergo egg retrieval and freezing, both to donate to other people and for her own potential use for the future. So Palany claimed in this case that when she told her supervisor she was doing this egg donation and freezing, her supervisor made some disparaging comments, was hostile to her, and ultimately terminated her. So she also sues under FEHA for discrimination and for harassment. So what the court here said is that FEHA protects discrimination and retaliation based on a pregnancy-related medical condition. So the court found that with these specific facts, an employee who was freezing their eggs for donation or for future use did not qualify as pregnancy-related. Because here what they're saying is that at all relevant times, Palany was not pregnant, she was not disabled by pregnancy, or there was no medical evidence to show that she couldn't perform the essential functions of her job. So why I think that this decision might change if it were to be presented before the court today. So first and foremost, most importantly, Palany was terminated in 2019. California in 2022, in response to the Supreme Court's decision in Dobbs v. Jackson of overturning Roe v. Wade, California responded by expanding FEHA to include a prohibition against discrimination or harassment based on reproductive health decision-making. So that happened all after she was already terminated. So what the California FEHA protection, including reproductive health decision-making, includes the decision to use or access a particular drug, device, product, or medical service for reproductive health purposes. So because this definition is incredibly broad, it's certainly possible that if this case were to come up before the court today, that the court would find that it could cover future reproductive health decisions, or it could cover donation for other people to make reproductive health decisions. So I think it would probably be decided differently if it were decided now. The court in this case kind of punted on the question of whether or not FEHA would apply if Palani was undergoing egg retrieval and freezing because she was experiencing infertility. So they didn't really weigh in on that. It focused more on the fact that here, this procedure was really very elective and it wasn't based on an actual pregnancy. And finally, this case had unique facts. Palani did not request any sick leave or time in order to undergo the procedure, so it might have been different had she done that for those purposes. What we would recommend based on this case is that treating all reproductive health and fertility related decisions as a protected characteristic. You should definitely update your EEO policies in your handbook, like Jeremy mentioned, to explicitly include that discrimination and harassment based on reproductive health decisions is prohibited. And finally, moving on to Perez. So Perez, the background of this case is a little interesting. So Thomas Perez was an underground haul truck driver. He claimed, and you're going to see where I'm going with this one, that he was injured during one of his shifts when his truck collided with the wall of a mine. Very relatable for us in Los Angeles, but yes. So he was examined by an EMT on site hours later, who claims obviously that, he was examined by an EMT on site who said he did not see any outward signs of injury. Later on, Perez sees his own doctor, who then says he's got muscle spasms, he needs muscle relaxers, he needs to be off from work for 5 days. 5 days quickly leads to 18 days by the time he ends up coming back to work. So his employer is a little dubious that this accident actually happened. So the employer decides to undergo an investigation. First off, it finds that no evidence of any collision ever happened. The employer next gets a tip from another employee that the employee says Perez was faking this injury because he wanted to take some time off to work on his own personal business, which were rental properties. So what the employer decides to do here is hire a private investigator and to follow him and find out whether or not he was actually disabled or in any kind of discomfort. So not only was that not the case, but the private investigator got video footage of Mr. Perez gambling, using power tools and equipment, and in fact, working on his rental properties. So Perez comes back to work 18 days later, and he is promptly terminated for faking this injury. Now, if you can believe it, which I'm sure you can, Perez then sues, claiming that his FMLA, or Family Medical Leave Act rights, were unlawfully interfered with. And when he was terminated, this was against FMLA. The case actually went into a jury, and the jury decided for the employer. So the case goes up to the appellate court. And now typically when an employee makes a claim for wrongful interference with their FMLA rights, they have to prove with the healthcare provider that they had a serious health condition. Now, as we all may know, it's fairly easy to get some healthcare provider to certify just basically about anything. So if an employer thinks that there might be something off with this certification of a serious health condition, they may require the employee to get a second or third medical opinion regarding the serious health condition. What's important to know is that that would be at the employer's expense if they wanted to do a second or third medical opinion. The employer can also require that they get a recertification from their own healthcare provider. But the court here is saying that the employer is not required to do that. If they're challenging the FMLA certification, they don't need to get a second or third medical opinion, and they also don't need to provide contrary medical evidence. Non-medical evidence, the court found, is enough. So here, these great videos and this great investigation and reports, the court found that the employer was allowed to use that to rebut the employee's claim regarding their medical condition. Because the California Family Rights Act, or CFRA, is modeled off of FMLA, and has similar provisions, it's very likely that it will be applied to CIFRA leave requests as well. So it's something to keep in mind. This case shows you that if you have reason to doubt an employee's claimed medical condition, you do have options here. And Perez is an example of where the aggressive exercise of this option paid off. So that's it for me. Thank you.
Thanks, Talia. Thank you. That was fantastic. I think you all know why I called her a superstar associate. It was so accessible. Thank you. And believe it or not, we are even a minute not even behind schedule. We're in advance. So we're gonna take a break now. And we'll come back in 15 minutes. 15 minutes, some schmoozing virtually or in person. And we'll come back. And Steve Rossi is going to tell us about what's going on with the most important piece of paper that I think any employer can have, which could potentially even save millions of dollars, which would be an arbitration agreement. So stick around for that. Extremely important to know what's going on there. Thanks, everybody, and see you in a few.
Recording in progress.
Now that we're recording, if you are a client, and do not have an arbitration agreement, and there's not some employee relations issue why you can't do it, it's kind of a no-brainer, and I'm sure Steve will, you'll come to understand that, Steve. And guess what? We have a fantastic template too, which we're happy to provide to clients. But anyway, over to you.
Thank you, Jeremy. Okay, so I've come and talked about arbitration agreements. It's got to be at least 5 years now. And every year I start off with a sales pitch for arbitration before I get into the updates on arbitration. But to keep it brief, I mean, I think many of you probably know arbitration has a lot of advantages. It's more private. You can get the result quicker. You might be actually more willing to take something to resolution where, if you're in LA Superior Court with a jury of your peers from downtown, that can be a very scary prospect. And then the really, really big benefit to arbitration agreements that I talk to anybody who has a significant number of employees is about protecting against wage and hour risks. Because if any of you have tried to comply with all the provisions of the California Labor Code, you think you're doing everything, and then later on you find out, oh, somebody made this one little tiny mistake, and people were underpaid by a few cents an hour, and it might, the potential exposure is tens of millions of dollars when you kind of add it all up, which is a very scary situation to find yourself in. But if you have an arbitration agreement and you successfully enforce it, then the class action risk goes away, and then you're just dealing with potentially an individual claim and maybe a PAGA claim. Which, are we updating on PAGA this year? You talking about PAGA this year? Okay, well, so just as a refresher, PAGA is people bring a claim on behalf of the state, and they can seek penalties, but it can only go back 1 year. It's a little more limited. It's terrible, but less terrible than a class action. But the other thing about arbitration agreements is now we have clarity on some protections relating to PAGA as well. So at the end of the day, I think I've only one time recommended not including an arbitration agreement, and it was where someone had one employee. And the cost kind of outweighs the potential benefit. But generally, for most of our clients, it's going to make a lot of sense. I could go on and on about it, but I'm happy to talk sort of offline. But today, I'm going to talk about not the benefits of arbitration, but sort of the second part of anybody's alternative dispute resolution plan, which is actually making sure you can enforce your arbitration agreement. Because California, despite having Supreme Court decisions saying that California favors arbitration as a method of dispute resolution, you would never believe it when you actually read all the cases invalidating arbitration agreements. And every year, there's some other little issue that some smart plaintiff's attorney sells a court on, where they say, oh gosh, this is the most unfair agreement we could ever possibly imagine, so you can't enforce this arbitration agreement. So we're going to talk about a few of those things. So the first one has to do with PAGA. So as a little historical background, it used to be you could not arbitrate PAGA claims because that's a claim on behalf of the state, and the state never agreed to any arbitration agreement, right? And then the Supreme Court said, well, actually, you could split the claim. So the person bringing the claim has their individual PAGA claim, and then there's the representative part on behalf of the state. And you can actually require people to arbitrate that individual claim first. And then depending on how it works out, you go and deal with the representative part. And so the benefit there is that, say someone brings a class action and a PAGA claim, well, you can potentially knock out the class action claim, and then you deal with the individual claim first to find out, is there any validity there? And if you prevail, then the PAGA case should go away. In this case, though, someone was dealing with, the company involved was probably dealing with an older form where they hadn't updated their form to deal with this sort of new development and what you're allowed to push into arbitration. And they basically said in the agreement that the employees waive their rights to bring a class action, collective action, and also a representative action. Now, if it just said that, what the Supreme Court precedent would say is, well, okay, that's not allowed, but because we favor arbitration, we can sever the unallowed parts, and we're going to say the individual claim goes into arbitration, and the representative claim will remain in court. The problem was that this arbitration agreement included a poison pill severability provision, which is not uncommon, and it's kind of a historical relic. And what it says is that if any part of the class action waiver or the representative action waiver is invalid, then the whole agreement is invalid, and we're going to go to court. And the reason those poison pills existed in older agreements is that there was previously, it's probably been, I don't know, 5 years or more, there was some just debate over whether you could find yourself in a situation where the arbitrator gets arbitration where it's a class action claim, and they actually proceed as a class action in arbitration, which nobody wants because it's really expensive, you don't get an appeal, it could be a big problem. But the Supreme Court, a few years back, made it very, very clear that even if you don't include a class action waiver in your agreement, there's no class arbitration. But so a lot of companies had included this sort of kill switch so that if it turned out that you couldn't actually waive a class, then the whole agreement gets invalidated. And so in this case, the court said, yeah, sorry, because you say you killed the whole agreement, if any part of this provision is invalid, we're going to invalidate the entire agreement, and so you get no arbitration. So the bottom line here is, if you haven't looked at your arbitration agreement in the last year, 2, 3, it's time to look it over to see exactly how you're dealing with PAGA claims and also what your severability provision says, because it's easy to get tripped up in. Okay, the next one is Cook versus USC. And I think this is probably the most important case I'm going to talk about. And in this case, an employee at USC sued for a bunch of various different claims, and USC moved to compel arbitration. They ultimately lost because the agreement had some provisions that are not super uncommon in a lot of agreements. So number one, the agreement did not have a termination date, so it would extend even after the employee's employment ended. It also, according to the court, lacked mutuality because it said Cook agreed to arbitrate her claims against the university and all of its related entities, and employees and subsidiaries and parents. And that's a very, very common provision in the agreement. And the agreement also applied to any and all claims. So it wasn't just limited to claims arising out of employment. And the court looked at this and said, well, okay, so the way this is written, theoretically, if this employee quit and they went to USC Hospital and they had a malpractice claim, the USC Hospital could require the employee to arbitrate, but the employee, say, if the hospital sued them for not paying their bill, could not force the hospital to arbitrate because the hospital was not a party to the agreement. Because the agreement just said, okay, USC is a party, the employee is a party, and the employee also has to arbitrate all their claims against all these other entities. And so they just said, yeah, that's unfair. That's too broad, goes on forever. It could cover car crashes with other employees, could cover any number of claims. And that case, could be distinguished because USC is a really big entity that's involved in a lot of different aspects of society, whereas some companies are going to be more limited. But I'm sure many of the companies that are represented here, could theoretically have all these related entities that deal with different things. And so my recommendation is take a look at your agreement, and we have to think strategically. And I'm not gonna give you a sort of one size fits all approach to this, because it sort of depends on your strategy. And so one strategy is, well, first of all, okay, one size fits all recommendation is definitely say the claims are limited to claims arising out of employment. That's easy. So then you're sort of taking away all these random other claims. And then you want to think about, are we going to actually bind our related entities to the agreement? And if you've only got a couple, it's easy to make them a party. If you've got hundreds of related entities, then it gets a little more complicated. We'd have to talk about different strategies there. But it's something, again, that's worth looking at strategically as you review your agreement this year. Okay. Okay, another terrible California law in the state that's supposed to be arbitration friendly. There's a law in the books, it was added a year or two ago, that says if the party requiring arbitration who has to pay for the arbitration doesn't do so in time, then the other party can withdraw from arbitration. They can get all their attorney's fees involved. So like not just relating to withdrawing from the arbitration, but any kind of work they've done in the arbitration, they can get sanctions and they can get all their costs and they go right back to court. And it's led to all these gotcha cases because it's very, very strict. What it says is that when the arbitrator provider sends, in most cases, the company, the bill, whatever due date that arbitration provider puts on the bill, it's actually due 30 days, in 30 days. And so there have been situations where the arbitrators will, say, oh, well, actually, you can go ahead and pay it in 45 days. Or, oh, you're a day late, we'll extend the due date. Or people have tried to make a credit card payment on the last day and the arbitration provider's credit card machine is not working. And because the arbitrator provider didn't actually receive the money on the due date, it's late. And the courts have very, very strictly applied this rule. And so, the main takeaway here is when you get an invoice, that's something that has to be paid as a priority. But there have been a lot of cases that have also kind of looked at this case, and this is sort of more of a technical thing. But basically, one court held that if you're subject to the Federal Arbitration Act, so meaning you're involved in interstate commerce or you elect to apply the FAA, then that federal law preempts this crazy California law. Because basically the FAA does not include this law, and also it's contrary to the purpose of arbitration. And so there's one good case. Unfortunately, the Supreme Court has granted a petition for review on that case, and I gotta imagine they're gonna reverse it. And there's a bunch of other cases that have gone the other way. And so my recommendation is still you should elect the FAA in your agreement, because if you say the Federal Arbitration Act agreement applies, then some courts have said this crazy California law does not apply. So I would still do that, and there's a lot of other reasons to include the FAA over California law. Okay, all right, so now this is another interesting aspect of your ADR strategy. So, the question is, when do you make an employee sign or agree to an arbitration agreement? The easiest time to do it is when they're onboarded, right? You give them a bunch of papers, they're willing to sign whatever, everybody's happy. But there are other times where maybe you need to change your ADR agreement. Maybe you never had one before. There are a lot of different reasons why you might roll it out to existing employees. And there are various different strategies for this. One way is you hand it to people and say, we would like you to voluntarily please sign this. Well, if you got thousands of employees, that gets to be kind of complicated, and sometimes people don't sign it, and the people who fall through the cracks are probably the people who may end up being a problem in the future. And so another strategy is you can send out an arbitration agreement to everyone and say, look, if you're still working here in 30 days, you are implicitly agreeing to be bound by this agreement. And there are a bunch of cases that say that works. And so then it's just a question of actually proving that that's what happened and they actually got it. But theoretically, it works, and we've had it work in the past in cases. Now, this case, though, raises the situation where the employee actually said, I don't agree, I'm not gonna sign it, I don't care that you say I'm gonna be implicitly bound by it, you can fire me if you want. And the company didn't fire them. And so that theoretical question always comes up, like, well, what if this happens? Well, now we know, at least according to one case where the court said, look, they said they refused, and you said it was a condition of employment, and you didn't actually enforce that. And so your alternative was to fire the person. So I don't think I would recommend against doing this process because I think most of the time it's going to work. But if you encounter a situation where someone explicitly says, I refuse, then you're going to have to think hard about how you're going to address that. Okay, now the last one, this is actually a decision from the Supreme Court. And it's good reading for a refresher on the kinds of things of what not to put in your arbitration agreement. Because the court looked at a lot of things about, what's unfair. And so, and this is sort of typical of what you see in older agreements, like, require the employee to arbitrate claims they're typically required, they would bring, but it says the employer can say sue in court for intellectual property disputes. And courts always say, no, that's not fair. It shortened the time period for when they actually had to bring the case. It said that if the company had to file a motion to compel arbitration, they would get their attorney's fees. And the court said, no, all those things are not allowed. And so that's sort of old law. But what's new is that they looked at, can you save an arbitration agreement when it's got these provisions that are not allowed? And there's this concept of unconscionability and severability. And the idea is that if an agreement's got some unfair provisions, the court is allowed, but it's not required to delete those unfair provisions. And if after deleting those, it's fair, then they're allowed, but not required to enforce it. But this law had developed in our so-called arbitration-friendly state, which I called the two strikes rule, which was you could have one unfair provision, but if you had two or more, it was invalid. And courts just uniformly said, oh, I found one, oh, I found another one, and it could be this very minor little thing. And they would say, okay, there's more than one, it's invalid. And the Supreme Court actually said, no, there's no strict, two provisions and you're out rule. But they did say you kind of look at the whole agreement as a whole, and you're trying to decide, is it tainted with illegality? And is it, really, really unfair? And so it's supposed to be more of this holistic analysis, which is correct, but they didn't really say what you should really look at. And I'm not really expecting totally different results in the future, but maybe we'll get lucky. And they'll be a little bit more generous about, striking out offending provisions. But the concern of the courts is that, if they didn't do it this way, companies would be encouraged to put in a bunch of unfair stuff, knowing that, oh, what's the worst that'll happen? The court will just say, well, that unfair provision doesn't apply, but the rest of it does. So my recommendation to all of you, as always, is have somebody take a look at your agreement and just, check for provisions that have been ruled on repeatedly to be invalid, because there's a long list of them that we see all the time. It's very easy to follow. Okay, so I think is that it? That's it.
Fantastic. Thanks, Steve, for that update. Makes your head spin a little bit in terms of all of the things that could potentially go wrong, but hopefully the moral of the story is, or at least a simple one is, just call Steve and talk it through it, then we'd be happy to do that. And now, as you can see, it's my distinct pleasure to welcome to the stage or podium our newest partner, and we are so lucky to have him, Mike Marino, who was for many years the senior vice president at Warner Brothers Discovery, where he oversaw all of the studio employment related matters. And now we're lucky enough to have him here. So thanks, Mike, and walk us through some wage and hour issues.
Good, thank you, Jeremy.
Thank you.
Appreciate it. Okay, well, I am very happy to be here today to present on, it's really the most fundamental of fundamental California public policies, and it is, of course, wage and hour, as Jeremy said. I'm Mike Marino. Those of you who know me know that I spent approximately the last 2 decades at a major entertainment studio. And those of you who know that industry know, particularly with respect to film and television production, that wage and hour presents a steady stream of unique issues. But now that I've joined MSK, it's been very interesting for me to see how these same challenges extend to other industries as well. And California wage and hour is notable because many of its central principles are over 100 years old, which of course proves the old adage that bad facts make century-old fundamental public policy. So let's get into it. Now, Jeremy covered the essential territory here on the minimum wage, but there's actually a couple other notes I thought would be interesting. One is that, of course, last November, Proposition 32 was on the ballot, which would have raised the state minimum wage to $18 an hour this year. It failed to pass. The Chamber of Commerce noted that this is the first time that California voters rejected a statewide minimum wage increase, which is a sort of an interesting a fact to have in the background, in terms of what could happen, in coming years with respect to what California voters in particular think about some of these issues. But it was a close call, as you can see. It was 50.8% against, 49.2% in favor. So still pretty close. The other thing I thought I'd mention too is that Jeremy noted the 68,640 is the exempt limit, but just remember, if you've got a collective bargaining agreement, you need that 1.3x. Your wage rate's $21.45 an hour. So the minimum wage is, of course, adjusted to the consumer price index, it's inflation adjustments, so it's going to go up. And then finally here, the DIR website in California, which I put the link on the bottom, has really good information on it, including that list of localities with the higher rates. And Jeremy called out the local and important to us, but there's a lot of them. So that is definitely worth looking at. And some of those rates are much higher, 1650. There's also really good info sheets on fast food and healthcare industry, of course, special rates of there. Okay, so our first case here, we'll go to the California Supreme Court, talk about the compensability of time spent waiting on employer premises. This is Huerta versus CSI Electrical Contractors. And this one, of course, when I read it, reminded me of the studio lots around town, where you face a similar issue, but of course, there's lots of other applications throughout the state where this type of issue can come up, including here. CSI is a solar power contracting firm at a remote power plant, sort of Northern California. After commuting to the plant, the employees spent actually a considerable amount of time making their way through 2 security checkpoints on a several mile long access road before they finally reached a parking lot and then clocked in. And they experienced a similar process on the way out, the end of the day. So all of that, of course, took a lot of time. See, I think where this case is going. Huerta, who was covered by not one, but actually 2 collective bargaining agreements, filed a wage and hour class action for unpaid hours worked based upon the amount of time all of that driving around took after he reached that point of entry. And a couple of issues landed eventually after litigation with the California Supreme Court. So the court, it was interpreting wage order 16 here, which is relevant because wage order 16 is one of those that's similar to all the other wage orders, but it does have some specialized components to it. It's the one that applies to the construction, drilling, logging, and mining industries. But in interpreting that order and specifically what is compensable time work, what is hours worth, the Supreme Court decided the issues in Huerta's favor with respect to the amount of time that he was driving around for the most part. So here, I think it's important to consider that Prelican case, that's the APA case from 2020 involving bag searches. That was sort of a similar set of issues, and the underlying principle in both of these cases is really the same, which the key issue being employer control. Sufficient employer control means compensable hours worked. That's sort of the bottom line. The problem with that is that it sounds simple, but there's always a facts and circumstances element. And sort of in real time, in the moment, it can be very difficult to figure out how much control are we really exerting over the workforce. So here, and I pulled this quote, I put the bold words in there from the court's decision, where you get an idea of where they were going with this. When an employee is required to spend time on the premises waiting, undergoing an employer mandated procedure, that time is compensable. So I think, that gives sort of that sense of what the court was looking at, because it was very interesting. And again, wage order 16 has a little bit of a variation in it from the other wage orders, but the court also decided that on premises driving around once where it got through the checkpoint was not compensable. There wasn't a sufficient amount of control, even though you had to follow all the traffic laws and things like that. If you're on the studio lot cart and you got to use proper hand signals, none of that counts as control. So that time was not compensable. The court was also very careful to distinguish commuting time, ordinary commuting time. It didn't want anybody to think that what would be an ordinary commute could possibly be considered compensable hours work. So a lot of really interesting issues sort of permeating this case. But again, if you have that situation where employees are getting delayed for whatever reason to do some form of inspection or something like that, you're going to want to take a look at it. There was also a meal period issue in the case that I think had a relatively unsurprising result, in that because of that remote location, the employees were not allowed to leave. Yet they were relieved of their duties during a meal period time, but the court said that, again, because of that level of control, that actually was compensable time during that meal period, even though they weren't working. There is too, in this case, sort of an unwelcome line that I thought I would point out in addition to the decision, which is this, and I'll just read it. It said, "We note that California's wage and hour statutes do not incorporate the federal de minimis doctrine." So that was always something that I would look for when we made these at studio, these arguments in the wage and hour arena, is whether we could argue that it's de minimis. And here you have a statement in a California Supreme Court case, not a holding, but a statement that doesn't apply. So it's something to think about. Next up, we go to the California Court of Appeal. In the Chavez versus California collision case, this involves settlement, section 998. That is a statute in litigation that always captivated me. It's, of course, the state version of a federal offer to compromise. It's a fee shifting mechanism designed to encourage plaintiffs to accept settlement offers during litigation. So here we had 3 employees sue their employer, an auto body shop, for on 11 causes of action, all related to wage and hour. The employer made 998 offers to all 3 of them. 2 of them accepted, they dropped out of the case. The third one ignored the 998, went to trial, he won. But he failed to obtain a judgment that was more favorable than the defendant's 998 offer. And in fact, in this case, the employer made 2 998 offers, and the judgment was less than both of them. So that was sort of an interesting fact. The trial court applied 998, and the employer was able to snatch victory from the jaws of defeat. The employee ended up owing $33,000 as a judgment to the employer as a result of that fee shifting statute. And then the Court of Appeal got a hold of the case, and they reversed the trial court, holding that the labor code's special fee shifting provisions that are embedded in some of those statutes overrode 998. So what does that mean? Well, as you can see at the bottom, 1194 and 218.5 displaced 1032, making 998 inapplicable. Fun with wage and hour numbers. So to break that down, in the absence of a specific labor code provision, the court said, costs are awarded in employment dispute matters under Civil Procedure Code 1032. And that's the code section that says the prevailing party in the lawsuit gets their fees and costs. So that's the general rule, and 998 is keyed off of that provision. But where statutes have their own internal fee provisions, those are going to override 1032, which is then going to impact the ability to use 998. So that's what happened here. Labor Code Section 1194, which deals with minimum wage and overtime violations, only allows a prevailing employee to recover costs. So the court said, since that's only for employees, employer can't get a recovery. So no 1032 application, so no 998. Same with Labor Code Section 218.5, because that's the one that says an employer can recover costs or in suits for unpaid wages, but only essentially if the action was frivolous, which is really almost never, despite what we often think about those cases. So there you have it. The bottom line here, the utility of Section 998 offer reduced in these types of labor cases. But of course, that doesn't mean that there aren't other reasons to give it a try. But I thought this one was interesting. Okay, next up, Labor Commissioner case, Cheesecake Factory, involving liability for subcontractor wage violations. Now, this one is really interesting. It's a matter that actually started in 2015, and it's only now resolving. And the reason that 2015 is important is because that is the year that AB 1897, which is the statute that had to do with subcontractor liability, was put into law. It's now part of the Labor Code as 2810.3. So what happened here? Well, every time I've been to a Cheesecake Factory, the place is always packed, which means you can imagine at nighttime, it's got to be cleaned up really well. So Cheesecake Factory contracted with AmeriClean to do their nightly cleaning across a swath of Orange County and San Diego County restaurants. AmeriClean further subcontracted the work to a much smaller contractor. And that subcontractor eventually got cited by the Labor Commissioner for underpayment of about 600 workers to the tune of multiple millions of dollars. And because that statute had just come into play in 2015, which again now Labor Code 2810.3, the commissioner extended the liability to AmeriClean and Cheesecake Factory. No longer sort of that joint employment analysis required, because the statute allowed it to happen very directly. So the parties were in it, and they stayed in it for a long time until last year when the case settled. It was $1 million settlement, as you can see. And of course, as so often happens in matters like this, the subcontractor, who really is the one that was supposed to be responsible for compliance with all of the laws, paid the least amount of money. AmeriClean somewhere in the middle, and Cheesecake Factory paid $750,000, 3/4 of the total settlement amount. So the Labor Commissioner, I think this quote that I pulled here says it all about what this case is all about and what you want to watch out for. Client businesses can no longer shield themselves from liability for wage theft through multiple layers of contracts. The enforcement benefits the workers who, of course, deserve to be paid, but also legitimate businesses that end up underbid by what she called wage thieves. So again, something to be very careful about when you do have subcontractors. This law does exist. The Labor Commission law will obviously use it. And so you're going to want to remain vigilant about the activities of the subcontractors, particularly if they're on your site, job site. And then a couple of other things, of course, when you're making that contract, you want to think carefully about the indemnification clause that you write and ensure that you've sort of thought through scenarios like this and tried to cover them, which leads to the final point on this, which is also vendor capitalization. right? Because the best indemnification clause in the world is not going to save you if the vendor can't pay it. And as we see from this matter, we know who ultimately someone will pay, and we know who that's going to be. Okay, so last case here today that I'll share with you, we get to do something that's very hard to do in California wage and hour cases. So we'll savor this moment. We're going to end on a mostly high note. This case, again, is coming from the California Supreme Court. It's Naranjo versus Spectrum Security Services, involves wage statements. And as you can see, I put when ignorance of the law is an excuse. So what happened here? The plaintiff, Gustavo Naranjo, worked for Spectrum Security Services. Sort of an intense job. They transported prisoners. They were guards who transported prisoners for medical attention to the facility. He left his post somewhere along the way. He got fired for that. And then brought a class action alleging meal period violations. And again, this case has been around for a long time too, which is relevant to the fact pattern here because the employer made its decisions before that whole Murphy line of cases that clarified that premium pay for meal periods was a wage and not a penalty. So the class action is brought for meal period violations, plus all of the derivative claims that accompany, a meal period case, including the Labor Code 226, which is sort of the star of the show in this case. That's the statute that covers wage statements. So bottom line here, the good news, the court held that the Section 226 penalties that had been imposed along the way in the litigation were actually unwarranted because Spectrum had a reasonable good faith belief that it conformed its conduct to the law. And because as a result of that, the company did not need to be deterred or punished. So that's the good news. Less good news is they didn't get a total pass, of course, because the wages were still found to be underpaid. So the injunctive relief, the restitution of the lost pay, the attorney's fees, none of that got negated by this decision. The players are responsible for all that. But there's some really good language throughout this decision. This is one I actually think is definitely worth reading, especially if you're in the trenches at the LSE, for example. There's a lot of thought-provoking statement and language in there, background and analysis on Labor Code 203, which is waiting time that was also implicated in this case, has a penalty provision that, and they go into a lot of detail this in the case, which I think is interesting. The penalty provision for 203 reads a little bit differently from the penalty provision in 226. And what the court did here is they said, we recognize that, but we also recognize the need for employers out there to understand that we're going to interpret those two penalty provisions the same way. So that is language that appears in the case that I think is interesting and useful. Statutory construction as well. There's a lot of discussion from the Supreme Court about statutory construction, which in the wage and hour arena is really helpful to try to unpack because it's all statutory based. And then, of course, penalties. It's sort of an everything you ever wanted to know about labor code penalty sort of decision. And you can see here that I put a couple of quotes on the slide. Again, sort of reflecting the overarching holding. It said the legislature intended for the provision, the penalty provision, to target those who knowingly and intentionally flouted the wage statement law and not those who have made good faith mistakes about what the law requires. That's helpful language. And then they also said, although they were quoting the Ninth Circuit, regarding the age-old maxim, ignorance of the law is no excuse. This venerable principle, stated categorically as it often is, nonetheless has well understood exceptions. Actually went through a lot of those exceptions through criminal law and other areas, which is very interesting, but of course, but here too. So again, this is a useful case if you want to try to get out from underneath some of the penalties that apply in these favorable cases. And I think you can use it not just for 226, but also in other areas. I think the problem with it is it's going to be harder to find those areas where you would have really sort of a good faith excuse, reasonable good faith excuse, because over the years, over the 15 years, for example, this case has been going on. You know, certain of these areas have been tightened up, like or questions answered, like the wage is it a penalty? Is it a wage? All right, well, that is all that I've got for you today on wage and hour. I do thank you for your attention. As Jeremy said, if you have any questions about any of this, send them in and we'll try to get them answered for you.
All right, well, I'm giving all of us here at MSK a collective pat on the back because I think for the first time ever, we're just like perfectly on schedule. And like not cramming stuff in, so it's been really nice just to kind of take some nice breaths here. So to that end, we are going to take yet another break. But and for folks who are on Zoom, next time you could consider coming here, because one of the reasons why we do this is just give a chance to schmooze a little bit and meet folks who are also in your industry and other clients and lawyers who you've worked with or may have seen their name. But in any case, we're gonna take a short break. But before we do, I did promise that there's, for any lawyer here to get your MCLE, that there's a special code word. And when I heard that I got to pick one word, there's only one movie that came to mind. If you're gonna just have one word, and I'll give you the quote so that you can guess the one word, which is, just wanna say one word to you. Are you listening? One word. So what would that be? Anybody know? Okay, that didn't go as planned. It's from 1967, famous movie. Give you another hint, Simon and Garfunkel song. Really? Yes, very good. Okay, The Graduate, and of course the one word was plastics. Plastics being the one word for your code. So we're gonna take now, since I've been chatting, about a 13-minute break. And we'll see you back shortly to talk about benefit issues and immigration issues. And I have to say that for example, when I always hear benefits, my eyes start to glaze over sometimes, but not here, because Bob Lowe is one of the only people I know who's able to get up here and talk about benefits and have it not be boring. So you can tell me if I'm right or wrong, I suppose. Anyway, okay, see you in a few minutes. Thank you. Thanks so much. Recording in progress, and it's my pleasure to introduce you to Brian Fu in our immigration department. And I'm sure we've got nothing to talk about as a result of the new administration and how that might affect immigration. But so this is actually, I think, could be one of our more interesting segments on immigration. So I'm curious to hear what's going on and what might be ahead. So with that, Brian, over to you. Thank you.
Hello, everybody. My name is Brian. I'm an attorney in our immigration department, and today I will be talking about some immigration developments in this ever-changing landscape, and hopefully this will help you to think about what internal policy you might want to think about reviewing, and also how to be prepared for these ongoing developments. As we all know, there have been many changes already this early in the year, and there continue to be ongoing changes. Every day we're actually keeping an eye out for what's new. It's not even every day, it's almost like every hour. I'm checking to see what might have been updated, what we need to know about. And over the course of this year, we really do anticipate just more new policies. There's going to be more stringent processing of employment petitions and also of visa processing. And this is going to be across all of the Department of Homeland Security agencies, including ICE, USCIS, which processes those employment petitions, and the US embassies and consular posts abroad that process the immigration visas for international travel. So I wanted to start off with something that's been on the mind of many people, which is about the increased activity with ICE worksite visits. And you may have heard about this as well, but it's been brought up by a lot of professional contacts. Literally, everybody has been asking friends at other firms, friends at legal aid organizations about what to expect. And I don't blame them because, I mean, there is news that our government is going to release a campaign on social media telling people to self-deport if you're an undocumented person, and that they'll find you. So it's something that is very in the focus, in the spotlight at the moment. And our immigration department actually also released a client alert. And so if you're interested, and definitely go and take a look. And I think the alarming nature of these investigations is that they come completely unannounced. It's not like an I-9 audit where you'll get a notice beforehand. You know, somebody could just turn up unannounced. You know, these officers, they could be in uniforms, they can have guns on them. They might have uniforms that say police on them, even though they're ICE officers, they can have small clubs on them. And, you know, they may suddenly start to ask you questions once they arrive on the premises. They may be looking for specific people. They might ask you to, you know, unlock doors and let them into certain areas, or they might tell you to like self-group by immigration status, which is very common, where they might say, you know, if you're a US citizen, stand here. If you're not, then stand there. So all over the news, there is a lot of increased activity. There are reports that so-called sanctuary cities are being targeted. There is no strict definition of what a sanctuary city is, but it's generally referencing states that have certain limits on cooperation with federal immigration enforcement. And this includes states, say, like New York. There's also increased activity in different locations. Before, traditionally, there were sensitive areas that weren't really touched, such as hospitals or schools and playgrounds, and maybe even potentially, you know, places of worship that might be, you know, investigated by ICE officers now. So it's something that we definitely need to think about and be prepared for. So we really think that at this moment, it's really important that employers and employees know their rights. If needed, there can be trainings on, you know, certain rights that employees have, you know, their right to remain silent. If they're asked about their immigration status, they can choose to remain silent, knowing that they can ask if they're free to leave. And knowing these rights is important because, you know, when someone comes marching in, it's just very intimidating. Like, I don't blame them. I would be, you know, afraid myself. And it's helpful to have a set of items to follow, especially if you're front facing to the public. Say if you're a receptionist or security guard, you want to know what to do when somebody turns up unannounced. Say taking down the officer's information or contacting a designated person, which is something that we really recommend because having somebody, one person at least, who is familiar with the protocol, you know, knowing the difference between an administrative warrant or a judicial warrant, or you know, which areas are locked, which areas are private, which areas are public. That's very important for, you know, somebody that you can turn to when something like this happens. So something else that we also anticipate, increased activity with would be I-9 audits. This has kind of been, in the shadow of ICE raids. This is something that is increasing as well. I'm sure many are familiar with, the I-9 forms, time the completion of them in order to verify work authorization. But you may not have had an I-9 audit before, or it's very easy because it's so familiar to just forget certain things about, completing in terms of the I-9 process. So with an I-9 audit, what normally happens is you're going to get a notice of inspection, and usually they'll give you at least 3 business days. Sometimes they might say, do you waive your right to the 3 business days? And that's something that we think that it's best to not do. You want enough time to review your documents and prepare them, comprehensively. So traditionally, there are industries that are traditionally more prone to audits, but everyone should be ready. Particularly, companies that are in hospitality or in construction or in manufacturing or agriculture. These are all more prone to I-9 audits, especially at this time. And it's important to, do an internal review because if there is, a violation, even unintentionally, it can get very costly very quickly. There was an increase to the penalty fees that you may have heard about. This was done due to inflation, by the way, a regular increase, and it wasn't just because of the new administration, but it can be as much as so $2,789 per form, and violations can go up to $27,894. So very, very costly. So something to look out for and to be prepared for. So many of you may have started doing this, but if you haven't, we do recommend an internal audit to see if, training needs to be provided for new HR members, perhaps. There are also ongoing changes that HR should know about, such as, completing I-9 re-verification timely. Say if there was a recent termination of temporary protected status for Venezuelans in the US, and there are certain dates that you have to comply with in terms of re-verification of I-9 documents. And this, we anticipate could happen with other countries. Their TPS could be stopped very quickly, and then you would need to know when you need to re-verify. So we do recommend that you relook at policies if they haven't been reviewed, in a while. Also, you might want to consider, the pros and cons of e-verify. Not all states require e-verify, or maybe they only require it in certain circumstances. But if you don't use e-verify, it's possible that you might be more prone to an audit. So it's something that you can and might want to think about. And some other general tips, if, just to, provide some more information on things that are easily missed that we see. One would be actually, completing the I-9 forms timely. Sometimes it might fall on the back burner. Following the instructions on the I-9, don't ask for specific documents, or if an employee has given you a document that's listed, that's sufficient, there's no need to go and ask for, additional documents on top of that. And going back to Venezuela and the other TPS changes that may occur, just knowing that you need to properly re-verify when needed. So something else that has been on people's minds is DACA and the future of DACA. So it's a program that, was created to protect eligible individuals who were brought over as children, providing them with, the right to stay in the US and also with work authorization. Just important to note that it's not actually lawful status that has been granted, but it's prosecutorial discretion to not, so that you can stay in the US. So there is a difference. So some changes with DACA, just even earlier this year, I had to file a DACA renewal application and I just had to go and look quickly just to make sure that it was still even possible. It is still in ongoing development with court challenges. Pursuant to the most recent court order in January, right now, the USCIS is still taking DACA renewals and they are processing them. If it's an initial application, they'll still take your application, but they're just going to hold on to it and they're not going to process it at this time. So, I mean, everything is still ongoing. That's with the future of whether or not there's going to be DACA, and also just with DACA related issues, such as last year, there was, an expansion of eligibility for access to the Affordable Care Act health insurance marketplaces for people with DACA. But that's being challenged at the moment. So I think there's something like 19 states at the moment where you don't have access, even though you're on DACA. And just now about work authorization in general. So some types of work authorization, it depends on your visa category, but you might have something called an EAD card. And that's an employment authorization document, and that's used to demonstrate that you have work authorization. And it's something that needs to be regularly renewed. And in the past, if you were to, or currently, if you are to timely renew your document, sometimes if you're in a certain visa category, you get an automatic extension. Because as you know, it can take a very long time for renewals to be processed. So during that time, you might have a lapse in your work authorization, which is something that you don't want, of course. And because of the very, very lengthy, processing time, there was a final rule that was introduced in December of just last year, saying that there would be an extension from 180 days to 540 days. So a very large extension. But the thing is, this could change, especially for certain categories. If you follow the news, there's been, discussions about maybe changing it for, say, dependents of H-1B visa holders or dependent spouses of L-1 visa holders. So that's why it's so important to always, keep track of the dates, the eligibility category on your work authorization card, keep track of that expiration date, and it's best definitely to file any renewals as early as possible. Don't wait till the last minute and wait till, and rely on this automatic extension, because what happens if, if it's gone, then you're going to be stuck with no work and you're just going to have to, it's going to be hard to explain to your employer why you can't work because of not, renewing your work authorization timely. So we also see that there may be changes to other work authorized visa categories, and this is going to affect, again, dependents of, say, like H-1B visa holders or students. Many students come to the US to study, and with studying, they plan to continue to live and work in the US, often through programs such as CPT or OPT. But there could be, restrictions on work authorization for students. That's being discussed in the news very frequently now. And in order to be prepared, it might be time for students, for dependents to really think about what other options might be available to me at this time. So it's better to start earlier, because you're going to have to see if you qualify, if you can build a strong case, if you can come up with the documentation needed for certain visa categories. Say an H4 dependent might, if that person also has a bachelor's degree, maybe they want to think about switching over to getting an H-1B visa. If there's a more experienced individual, they could consider something like an O1 visa, but that has a very high standard, so you want to start early to see if you hit all the different categories that you need to. Usually you need to have a major, one-time achievement, or you need to have, you need to meet at least 3 regulatory criteria. Or say, there are other, strategies, say, if you work closely with an O1 beneficiary at the company, it's possible that you might be able to get an O2, which is attached to the O1. There are many different options, and it's important to start doing your research early on. And that's especially true because of changes that we see with USCIS processing and also visa processing. So the general process is that you file a petition with the USCIS, which stands for the U.S. Citizenship and Immigration Services. And usually at this time, employment petitions could take 3 to 5 months for processing. Some categories have the option where you can pay an additional premium processing fee of close to $3,000, and that would help you with premium processing for faster processing. And there could be a request for evidence while your petition is pending, and you would need to respond to that request for evidence, and then the processing would resume. So what we're seeing is that already there are longer processing times. And that's the case even if you decide to pay that premium processing fee. We've had cases where we've been waiting for a while and we contact the USCIS and we're told, you know what, we're going to give you a refund even, because we just can't keep with the deadline that we've given to ourselves of say like 15 business days. We just can't finish it. We're going to give you back, the premium processing fee that you paid, and you're just going to have to continue to wait. So that's one change that we see. Another change is that if you're doing a renewal, there is traditionally a deference for what was filed before. So if you say you've had an O1 visa for a number of years, and the renewal, you might, not need as much documentation as the initial filing, but there's talk about a change to de novo review, where they're going to look at your documents again, and they're going to take a closer look to see if, maybe you had an award in the past, do you still have an award in the present? Do you still have media coverage of yourself in the present? Do you still meet the categories of the qualifications for this visa category? And also with, say, employment-based immigrant visas, traditionally, after your petition is approved, there's something called adjustment of status in the US where you get your green card. And with that process, it's a very lengthy process where you might have to go in to do an interview. And right now, usually those interviews are waived, but it's possible that those interviews might be brought back. So you always have to be prepared for changes to the process. That's going to make, everything a lot longer than what you expected at the beginning. And so, I mean, we're already doing this anyway, but be especially careful with being comprehensive with documentation. If you're working with an attorney already, provide everything that you think might be helpful for the attorney to review to see, if it could be used and it might be helpful. And always file early, especially if you need to, start by a certain work date, or if you're waiting to change your status, because if you're changing your status in the US from one visa category to another, you're not allowed to travel internationally until you get a decision. Otherwise, you might have been deemed to have abandoned your petition or application. So you want to, do everything much earlier on, just in case, everything takes longer, and it has been taking longer. And that also goes with international travel. So a little bit about the process, you may know about this, but if your employment petition is, if you ask for an extension of status, then you can continue to work in the US. But once you, depart the country, you go on a trip or something, before you come back into the US, it's necessary for you to get a visa. you have to schedule an appointment with the US Embassy or consular post abroad. You need to submit a visa application called the DS-160 visa application, schedule a date. You go in, you hand in your documents, do an interview. Generally after that, in 4 to 6 days, you'll get your passport back. And then with that new visa in your passport, your employment petition approval notice, you can then travel into the US. But that could change with current changes that are happening. We've seen that there have been much longer visa processing times overall. It's possible that certain countries might have travel bans. And just there are different things that are happening with visa processing. Say, in the UK, what's happening is you try to schedule your appointment and you're told there's just too many people applying at the moment, so we're going to put you into a virtual queue. And then you just have to wait in that virtual queue and you can't do anything. You just wait until you get another notification telling you, okay, now we're ready to proceed, and now you can go access the visa calendar. Now you can choose a date, and it's just taking much longer overall. Also, sometimes people think, you go into your interview, you give them their passport, and you think, you're home free and everything's gonna be fine. But there's something called administrative processing, and that can happen where they need to verify your status or verify some other type of information that's inside your petition. And that can take much longer. So maybe you were planning, after my interview in a week's time, I'm going to fly back to the US. And that might not be possible. You might be stuck in your home country, or if you maybe did your interview in another country, you'd be stuck there until you get your passport back. So sometimes what's happened is because of the longer visa processing time, sometimes we've even had to, maybe help with, or talk to clients about maybe getting a second passport, which is sometimes possible if you have your passport for visa processing very often, and you might need another passport for you to continue to travel, because that's important to a lot of clients. And other things we're seeing is sometimes, you might qualify for an interview waiver because you are doing a renewal, you already had this visa before, or you're of a certain age, and then they say you qualify for an interview waiver. So you think, okay, I mail in my documents, in about 2 weeks' time, I get my documents back, and then I can travel. But what's happening now is that they might still call you in for an interview. So they're saying at the beginning, oh, you qualify for an interview waiver, superficially, but you know what? Actually, we reviewed your documents. We think that we still need to talk to you in person. They call you in, and then that adds more time to the process. So again, it's always best to plan ahead, schedule appointments well in advance. If you know that you only have a certain number of dates where you're going to be in a certain location, on your vacation, you might be traveling to a few different places. Choose a place where you're going to be staying the longest. You can schedule the appointment usually while you're in the US, so you can fill out the application, you can schedule your date, book it, lock it in, and then you go travel to minimize any interruptions to your trip that could happen. And if possible, it's best to leave a cushion. So I know a lot of people have very tight deadlines, but if you can, give yourself more time, give yourself 2 to 3 weeks, because it could take much longer, and you don't want to have to cancel your flight just because the visa processing is taking much longer than you expected. So that brings me to the end of my presentation. Thank you all for listening. Hopefully this provided you with more information as to what to look for in reviewing your internal policies and plans, and feel free to reach out if you have more questions.
Great, thanks, Mike. I'll just say I recognize that might not be relevant, some of these for every person here who doesn't deal with immigration issues, but certainly the first 2 topics, I-9 audits and ICE raids, especially the latter. Myself, I've gotten about 4 or 5 calls from clients, like, what do we do if they show up and just want to be prepared? that's something that our immigration department really handles, and that we pass off to them, as well as I-9 issues, which is somewhat unusual as a firm for MSK, that we have that kind of resource. I think we have about 8 immigration attorneys at MSK out of a total size of about 130 attorneys. Just by way of, it's highly unusual, just by way of comparison, at my former firm several years ago, we had about 800 attorneys and no immigration lawyers. So MSK is very unusual to have a robust immigration department, and it can be utilized for this intersection sometimes of employment and immigration, like those, which are very timely. And speaking of timely, Bob was not here. I assured him that I had some great things to say about him. And you all can back me up on that. But time to hear about some benefit issues, definitely not the last or least. Bob, thanks so much for joining us again.
Thank you. Yes. Good morning, all. Let's see if I can advance this. Yes. Okay. Good morning. I'm going to be talking about employee benefits issues. This is actually kind of interesting because this program was originally scheduled, I think, for like January 10th. Well, you're getting a very different program today than you would have gotten if I had given this program on January 10th. A lot has happened, a lot is happening, and really what I'm going to try to focus on are some of the issues that we're really dealing with currently, that we expect to be dealing with during the balance of the year. A lot of cases that are sort of percolating, some things that are before the Supreme Court. Mostly what I'm going to talk about are health-related issues, but I do want to start off with talking about one very significant retirement plan issue, and that relates to the recent LA wildfires. So employers, after the fires occurred, understandably, were looking for ways that they could provide some relief or benefits to affected employees. And one thing that should not be overlooked is that there are some potential benefits under your company's 401k plan that may be accessed by affected participants. And it's not too late to do this. This is still very much relevant and applicable. So there are, and these provisions exist because of changes in the law that were enacted as part of the Secure Act 2.0, which was enacted by Congress a year or two ago. But because these provisions are optional, employers don't have to provide them. Many employers did not turn these on in their plans until at least in LA County, until the wildfires came and people were really confronted with this issue and what can we do for affected employees. So if you have not already provided these benefits in your plan, this is something you really should very much think about. And as I say, it's absolutely not too late to do this. And these benefits are not, these are not going to rebuild anybody's houses. Let's understand the scope of this. But this is actually, it absolutely can provide some aid and additional benefits, temporary help to people who are adversely affected. So there are a couple of things here. One is that there's a one-time distribution of up to $22,000 that people can get, whether they're otherwise entitled to a distribution or not. If you take it, there's no penalty tax. You can spread the income tax over 3 years. It's subject to regular income tax, but no penalty tax for people under 59.5. You can spread the income tax over 3 years, and actually you can avoid the income tax entirely if you repay the distribution within 3 years. This is actually quite similar in structure to the COVID-related distributions that were available a few years ago, if anybody still remembers them, but the structure is very much the same. And this is available for up to 180 days after the applicable FEMA declaration. So the applicable FEMA declarations, there were actually 4 of them in LA County, took place, I believe, January 6th, January 7th, January 8th, around there. So people have until July 6th, 7th, 8th, something like that, to avail themselves of these benefits. So again, as I say, if you haven't thought about doing this, if you haven't done this in your company, this is something you can still do. And and this is basically going to be available to anybody with a residence
in Los Angeles County because that's the way the FEMA declarations are written. You don't have to be in specific one of the wildfire zones. You don't have to provide documentation that you were adversely affected. You're just going to have to sign a declaration that you suffered economic loss, very general terms, as a result of the LA wildfires. Nobody's going to ask you to enumerate what that economic loss is, or at least they shouldn't ask you to do that. In other words, it's sort of you self-certify. You have to be a resident of LA County. If your residence is in Orange County or Ventura County, sorry, you're not eligible because, again, of the way the FEMA declarations were written. So that's one option. The other relates to loans from retirement plans. If you have a loan provision in your retirement plan, generally the maximum amount you can borrow is $50,000. Again, for folks in these categories who are affected by the LA wildfires, they can increase that to $100,000. It's still a 5-year loan. But loan repayments during the 180-day period after the FEMA declaration, again, through July 6th, 7th, something like that, can be deferred for up to 1 year. So again, if for employers who are looking to provide relief to affected employees, this is still very much something you can add. You can, if you have a third-party administrator and you don't have this in your plan, you can call them up and add it. It may take them a few weeks to get it turned on, but this is still something people should be considering, and we definitely have a lot of clients who've done this. Okay.
Can I ask you a quick question?
Sure.
If someone has retirement benefits in an IRA, for example, that they've rolled over, are there any applicable provisions similar to that?
Yeah, I believe the same rules are applicable to IRAs, but we're focusing here mostly on employers and their plans. But yes, I think the same rules are available to IRAs. I can.
That's fine. I didn't put it on the spot. I'm just curious.
I can confirm that. Okay. Next, I'm going to spend some time talking about gender affirming care because there's a lot going on in this area, and this definitely impacts health plan administration. So first, I want to talk about this case, Lang versus Houston County, which is a 11th Circuit decision from last year. So if you go back in time, I don't know, 15 years ago, 10, 15 years ago, it was very common for group health plans to have blanket exclusions for what we would now refer to as gender affirming care. And over time, people asked, well, is this legal? Can we still have these exclusions? And many employers deleted those exclusions over time. But in this particular case, there was a public employee, and this is in Houston County, which is actually in Georgia, not Houston, Texas. And this plan still had that same exclusion. And the 11th Circuit Court of Appeals held last May that it was a violation of Title VII of the Civil Rights Act to have an exclusion in your group health plan for gender affirming care for a transgender employee. So a few months ago, if you would have asked me, can we still have these exclusions? I would have said, no, this is a violation of Title VII of the Civil Rights Act. And the decision in the Lang case was based on the Supreme Court decision in Bostock, which basically held that it was a violation of Title VII to discriminate based on transgender status. Okay, so, but hold on, folks, we're not quite done with this because the county applied to have the case reheard en banc by the full 11th Circuit. This is sort of, in the weeds of legal decisions. Just because a 3-judge panel of a Circuit Court of Appeals decides something doesn't mean that's automatically the final thing. Obviously, they could have appealed to the Supreme Court. That's probably coming next. But in the first step was to get the entire 11th Circuit, all the judges, probably, I don't know, 15 or 20 of them, they had to agree by a majority to hear this case, and they did. There was just actually oral argument in this case earlier this month. So we don't know how this is going to play out. And it's possible that the, the full en banc 11th Circuit will reverse the decision made by the 3-judge panel and decide that no, Bostock is just, and this was sort of the argument that the county made, no, Bostock is just limited to employment decisions. The way, whether you could hire or fire, whether you had to hire or fire, those kinds of employment decisions, it doesn't extend to group health plans. Lang, the 3 judges obviously said it did. And now we will hear from the full 11th Circuit en banc, whether they're going to agree with that, reverse that, probably heading to the Supreme Court after that. So this is sort of the big kind of global issue, I would say, with respect to gender affirming care. But there's more. There is also the executive order dated 1/28/2025 by the new administration that bears on issues related to gender affirming care for minors. And there are a couple of, now this is an executive order, it doesn't change the law. I am not advising any clients to do things differently because of this executive order, but there are some things in this executive order that are very concerning, okay? And that sort of jumped out to benefits practitioners, okay? So I'm not gonna read all the language. It's worth reading because if you've never looked at one of these executive orders, it's actually worth reading and see what they actually say, not just read the news reports on them, because some of the language is quite interesting. So in the first point, it says that the policy of the US is that it will not fund, and people focus on the word fund, the so-called transition of a child from one sex to another. Now, many group health plans, especially very large group health plans, have government assistance of various kinds. They may have employees who are on Medicare. They may get Medicare subsidies. There are prescription drug subsidies in a number of cases. These are significant dollars to these plans. These are a big deal. So the first thing that people looked at this and they said, whoa, wait a second, does that mean that we could potentially lose our government subsidies that we receive, say, for our Medicare beneficiaries or for certain prescription drug benefits if we have this benefit, okay? That's question number one. It's an unanswered question, but it's definitely something that we're watching. The second thing that jumped out at me from this executive order is the reference to the WPATH guidelines. Now, you may not have ever heard about this, but in administering group health plans, in making decisions about medical necessity, what's covered, all kinds of stuff, the insurers look to certain, medical standards and medical guidance, okay? And in this area, the WPATH guidelines have been used to determine what benefits for an individual seeking gender affirming care are medically necessary and not medically necessary. And for example, if you have a plan that's administered by Anthem Blue Cross, okay, not exactly a radical organization, they're using these WPATH guidelines, okay? So they're out there and being used, and this order has some extremely critical language about the WPATH guidelines. So that's also very much kind of up in the air. So again, I'm not based on this executive order telling people they should change what they're doing, but it is something that we are definitely watching to see how this plays out. And you may also be aware that this executive order has already been challenged in court. There's a lot of litigation around it, but this is absolutely something we have our eye on. Yes. Nancy, hello.
Hi, thank you. Could there be an executive order that has similar language but in regards to contraception or abortion services provided in healthcare plans?
Potentially. I mean, the scope of executive orders seems to be very broad these days.
Right, but that's one way to change what's provided to.
So, I mean, basically the way these executive orders work is that the idea is they're sort of directive to the I didn't give you the full text, but if you look at it, it's basically directives to the relevant agencies to eventually produce guidance, rulings, regulations, the various types of guidance. So really the question is whether we will eventually see a set of regulations coming out of, HHS, for example, that say, we're prohibiting you from using the WPATH guidelines or something of that nature. Or we're conditioning the funding that we would give you on, deleting the certain type of care. Okay?
Yes, they can apply that.
Yeah, yes, I mean, again, that we would expect legal challenges, and this is gonna take a while, but, for plans who are, counting on that check from the government, this is going to be a hard question to resolve, potentially, if that's what it comes down to.
Particularly because the funding you're talking about may not just be limited to that one issue in theory.
No, absolutely. It's and in fact, it's not limited to that issue at all. It's really limited to other stuff. Okay, it's like, as I said, it's mostly related to Medicare, people on Medicare and certain prescription drug benefits. Okay. Also, while we're on this same subject, I have to talk about the Skrmetti case. I think that's how you pronounce it. That's the case that was recently argued in the US Supreme Court about a Tennessee law that prohibits medical providers from providing gender affirming care to minors. This was challenged, it was challenged by the US, of course, by the prior administration based on equal protection grounds. The Supreme Court just recently heard the oral argument in this case. Now, this is a case that this is a law that applies to medical providers. It does not apply to group health plans. So in this case, we sort of have a similar situation. This, Nancy, is the situation that's kind of similar to abortion in the Dobbs case. Because if the Supreme Court upholds the Tennessee law, then you could have a situation with respect to gender affirming care for minors where some procedures are legal in some states and illegal in other states. Exactly the situation we have now with abortion under the Dobbs decision that the Supreme Court issued several years ago. So that's and I've looked at least the Tennessee statute. I haven't looked at I don't know about every statute out there that in other states that may apply this, but the Tennessee statute specifically only applies to medical providers. There's nothing in there about aiding and abetting like there is in the Texas statute related to abortion. So there's really no specific concern for plans or plan sponsors, but the issue comes up is how will plan sponsors deal with this if the Tennessee law is upheld under the Skrmetti case, and you have a regime where some things are legal in some states and illegal in other states. Now, you may recall that when the Dobbs decision came out, many employers and plans, especially in California, who had sort of more nationwide operations, they provided travel benefits so that individuals who were residing in a state where they could not get a procedure that they needed could travel to a state where they could get a procedure that they needed. This was sort of a few years ago. This was pretty commonly put in. Plans might want to look at this again in this area. In particular, in a number of cases that we were involved in, we actually advised employers to make it broader than just abortion because there were concerns about mental health parity. If you only applied it to abortion and nothing else, did you create a parity situation? So again, this is a situation we're watching. We'll see what the Supreme Court decides. But if you have travel benefits in your plan, you may want to look at them to see if they already cover this or if you want to extend that to cover this, should the situation arise where we now in effect have laws in some states where this procedure is legal and in some states where it's not. Okay, now I'm going to talk about the Braidwood case. This is another case that is in the Supreme Court, and we're going to get a decision on that this year. As you may be aware, under the Affordable Care Act, I know lunch is coming. I'm going to go through this quickly. Under the Affordable Care Act, plans are required to provide preventative benefits without any cost sharing. This is stuff like colonoscopies, mammograms, checkups, well baby visits. I mean, the list is very long. Certain vaccinations, okay. But the statute does not enumerate what those preventative benefits are, okay? The statute provided that that determination would be made by an organization called the United States Preventative Services Task Force, which is actually a body of experts that's appointed by the Secretary of HHS. It's kind of interesting to see how that'll play out with the new Secretary of HHS. But that's not the issue in this case. The issue in this case is whether this provision is constitutional, and it raises a issue under a provision of the Constitution that you and I probably don't spend a lot of time thinking about, and that is the Appointments Clause. That was the basis for challenging this, because these folks on the USPSTF are not appointed by the president and confirmed by the Senate, but rather they're just appointed by the Secretary of HHS, and they're good to go, okay? And the Fifth Circuit Court of Appeals in this case held, oh no, that violates the Appointments Clause, and therefore this whole provision about preventative care could be undermined. Now, in the Braidwood case, in the Fifth Circuit decision, the court limited their decision solely to the employer in that case, and so it's not a nation. It hasn't upended the rule for everybody. Okay. But if the Supreme Court decides this case, and we'll see how they go, this could also be undermined, and the rule in the ACA, which has been with us now for getting on 11 years or so, could be rescinded, and maybe plans won't have to provide these these benefits with no cost sharing. So this is a decision we're watching that's in the Supreme Court this year. I'm gonna talk very briefly about because our time is short and I know lunch is coming and I don't want to stand in the way of that. There's some mental health parity regulations that were enacted at very late in 2024 that imposed some additional requirements on plans that people were not expecting. This is a complicated discussion and a very short time to discuss it, but basically the statute requires plans to review non-quantitative treatment limitations. Though quantitative treatment limitations are things like number of visits you get to, for a certain, to go to a certain provider. Non-quantitative treatment limitations are things like, is it medically necessary? Is it experimental? Do you have to go through, certain steps before you get a certain benefit, that kind of thing. And the statute, and so the idea is you want to compare those in your mental health benefits and your medical and surgical benefits and determine that those are equal, that you're not treating the mental health benefits worse. And plans are required actually to do reports on that. Some plans did, some plans didn't. The government looked at the reports, found them deficient. So they came up with this regulation that now requires plans to have a qualified service provider to go out and provide these reports. And it's effective in 2025 now, like with 3 months advance notice. The lobbying organizations are challenging this, and my advice to clients is don't run out and hire a qualified service provider just yet. Do your reports internally like you've been doing them in the past, but let's see how this one plays out. Mifepristone, if you thought we were done with that, with the Supreme Court decision that denied the plaintiff's claim. This is the case over the abortion medication that was challenged based on the validity of FDA approval. The Supreme Court denied that, but denied it on standing grounds. In January 2025, federal district court let attorney generals who were a different set of plaintiffs keep the litigation going. So we'll see what happens with that. Also of interest is a Texas case in which they're trying to fine a New York doctor $100,000 for providing abortion pills to participants residing in Texas. Lastly, a little bit of good news, and that is those ACA reports that you might have gotten, 1095C forms. You don't have to give out paper forms anymore. You can just post a notice on your website that says that they're available. And if anybody asks for them, provide them. I think it's unlikely anybody's gonna ask for them. So that's a little bit of a paperwork burden that's relieved. And I think that's my last slide. Yes, that's my last slide. So I'm done. I'll stick around and take any questions.
Thanks, Pops. Thanks, everybody. And I remain shocked that I find what you say so interesting, even though I don't really fully grasp it. It's still.
Well, I'm happy to answer any questions.
Thank you. Thank you. Anyway, as Porky Pig often says, that's all, folks. Thanks so much for attending this year. And even if you're on Zoom, if you happen to be in the area, come on up, see us, have some lunch. Caitlin, was it Nobu that we got it from? Yeah. But thanks so much. See you next year. Appreciate your time.